All right, are we going?
Yep.
Okay, so my name's Grace Ross, and I'm the staff person for the Mass Alliance Against Predatory Lending. I'm not a lawyer. This is not legal advice, and you're not paying for it. So, did you just miss that?
Nope.
Okay.
Can you do it again?
We're going to do standing. We're going to be more informal than usual, and we're going to see how we do on banging through this. So, the key thing in this fight is that having the plaintiff in a position where it has to prove standing is our friend. We couldn't be in a better position. Why? Because one, they still, even though we've gotten pretty good at getting the evidence, they still have more of the evidence. So we want them, the burden of proof on them, and we want them to have to prove it under the standard of review required under standing. So for folks who are not lawyers, most of us have watched like criminal court TV kind of things. The thing about criminal law is that the standard of review, the level at which the evidence gets reviewed, is predetermined. But on the civil side, standard of review is very different depending on which thing you're reviewing. And one of your obligations as a litigant is to tell the judge at what level they're reviewing the evidence. And it can be everything from barely having to prove anything at all to basically having to cross every T and dot every I. So the standards of review vary from the far extreme on one end to the far extreme of the other end. We want standing, so both because they still have more of the paper evidence, and courts like paper evidence, and because we want the standard of review that's invoked when we can force them to prove standing. So, to start with, what is standing? Most of the courts that we're dealing with in terms of after a purported foreclosure in an eviction case have no clue what standing is. So you're up against a hurdle of trying to get the judge to understand what standing is. My favorite definition of standing legally is the Wex definition that basically says that standing is what a plaintiff has to prove to bring a lawsuit. For some reason, the courts keep trying to say defendants need to prove standing. You don't. And here's the logic for why. When you, standing is actually a legally defined term, and it comes from the Old English, and it literally means the right to walk into a courtroom, for instance, and stand in front of the judge. So if you like physical analogies like I do, it means that you have to do the things to cross the threshold into the courtroom so that you can stand in front of the judge. The reason a defendant doesn't have to prove standing is because you're there, you're not choosing to be there. You get dragged in there by the party who brings the lawsuit. The party that brings the lawsuit is the one that has to meet the standard to be in the right place. So there are a number of factors that have to do with standing, some of which are kind of intuitively obvious. You can't, have a murder case in Boston and try it out in Hamden County. You have to be geographically in the right court. You have to be in the right court in terms of what's referred to as subject matter. So I can't be, and I know people hate this analogy, but it works, dragging a dead body around and go into small claims court and ask them to determine whether there's a murder going on or not. Guys, that's too much.
Just put it over there, leave it alone.
So
Shining off the board.
Oh, wait.
No.
So you can't be in the wrong court for the wrong subject. The other issue is that you have to be somebody who has a right to bring the lawsuit itself. So there's, well, I'll use the logical analogy first and then we'll work our way to the law. But the analogy I always use is, you're in a bar, you watch a really horrible bar fight, somebody gets really badly beaten up. Do you have a right to bring a case? No, because you were not personally injured. You're not personally injured by it. You're not personally in a place to benefit from it. But if the person who got beaten up turns out to be your wife, That still probably isn't enough, but if she were pregnant and the child died because of the beating, then maybe you could show you had enough of an interest to have a right to bring the lawsuit. So the courts are supposed to look at whether you're somebody who actually could have been or could be damaged by something that happened. That's the standard that's mostly used. There's actually an older standard that I think for our purposes we sort of need to re-inspire, which is whether it is simply a clear violation of the law. There used to be a standard of standing that just was your rights were violated, even if you couldn't prove damage. Be that as it may, what matters here is that when we're in a eviction case after a supposed foreclosure sale, they can't be in an eviction case if they don't have a right to evict you. And the most basic thing is that they have to own the property. I can't just go, oh man, I like David's house. I'm just going to throw a couple of pieces of paper in the registry of deeds and evict him because I don't own the property. It's not possible. So this is the most fundamental issue here. Now remember that in housing court, the judges who sat for a long time, well, and the new judges don't know any better, they didn't have to decide mostly about whether the party in front of them had standing, or at least they didn't think they did. Because if you're a landlord and you've leased the property out and now you're trying to evict somebody from the property, you owned the property before you leased it out. So they didn't have to think about this. And it's a big piece of the problem. Judge Winnick, the chief judge in Boston, has gone on record saying, I am not responsible for deciding standing, period. And actually Kerman who's usually very good on this stuff, in Northeast Housing Court had kind of taken that position too. My assumption with Kerman, because he's very smart and very committed to getting the law right, is that he would have moved on that if the lawyers in front of him had kept arguing it. Anyway, but we want this because it's our whole point. If you don't own the property, you can't start an eviction case because you simply don't have what gets you into the subject matter of the court. The only court that can do summary process cases that has jurisdiction over ownership as well is Superior Court. So if they're in housing court or they're in district court, they're outside of the jurisdiction of the court, not just the subject matter of summary process, but jurisdiction of the entire court if they don't own the property. So we get to go after them for owning the property. We get to go after them for owning the property as a defendant, which means the burden of proof is on them. They have to prove standing. We don't, and we're in a place where the case can get thrown out if they don't own the property. So we've been arguing this issue about standing for summary process or eviction cases, the pro se folks, for a long time. There is actually a long history in housing court cases where the judges have allowed, not in cases where there was an ownership issue, but in cases where the party that brought the case wasn't the actual owner, they brought it in the wrong name, has been going on for a long time. So Hatcher came down in, I think it was May 15th. Very much grace. Where did I put the, oh, there it is. We got it. So Hatcher, the Hatcher decision came down from the SJC, I think it was May 15th of last year. And the pro se folks had actually brought several lawsuits against the Worcester Housing Court that had all by the time Hatcher came along, had all been docketed at the full SJC. And one of the things that the homeowners said in their briefs was that they really wished that all these great decisions have been put down about the jurisdiction of housing court, for the last number of years because of the foreclosures, but they really wished that the SJC had ever used the term standing. because we knew it was about standing. Standing's a concept that's really easy for people to grasp who aren't lawyers. And why, if they had just ever used the term, then maybe we could use it to really push the housing courts on, and these eviction cases in general, on why the plaintiffs had to prove standing. And so Hatcher comes down, and Hatcher is actually a situation that has to do with the misnaming of the landlord lessor in a standard tenant landlord case. But finally, Chief Justice Gantz from the SJC takes on, in so many words, the issue of standing in a summary process case. So for those of you who aren't lawyers and who are watching this tape, when you look at a lawsuit, I generally recommend that you start with the discussion section. If you can't make sense of the discussion without reading all of the history of what happened, go ahead and read all of the history of what happened. But it's often easier to start with the discussion section. So understand that the fight about trying to get eviction cases looked at from the place of standing has been going on for, we went back to at least 2014. So, for instance, in the Worcester court, where a lot of pro se homeowners have had to fight for years, the Worcester Housing Court has probably been asked to address whether a plaintiff has standing as a starting point, 1,500 times, let's say. And they've done it maybe once that I know of. No, twice that I know of. Because they don't get it. But every court case, the stuff I laid out at the beginning, every court case, everywhere in our jurisprudence in the United States requires standing, period. There's no question about it. Some cases you don't really have to look at it because the facts are going to show standing immediately. You don't need to figure it out. But you always, always, always have to do it. And I've given you guys, as always, I'm not always thrilled with writing that I've been the lead on because I don't write as cleanly as our lawyers do. But I've given you our argument, standard argument on standing. And it's been evolving, but the core cases quoted in there have been quoted for the last 4 or 5 years. But Hatcher should be a breakthrough for us because finally we have something directly from the SJC where they cannot say that we're, somehow stretching the interpretation of what was meant. And if you combine Hatcher with the Rosa decision, it makes the argument absolutely clear cut how Rosa was saying that they had to have standing, just they didn't use the term. The SJC didn't use the term, which is unfortunate. But anyway, to Hatcher. So if you go to page 8 in the version of Hatcher I've given you, which is where the discussion starts, you'll see the discussion starts by titling Standing to Bring Summary Process. It's the language we asked Gantz to use in the other pro se homeowner cases, and he came down and gave us exactly what we asked for. So he brought full, clear center, no eviction case anymore can say, no judge who's read the law can say, I don't have to look at standing. It's right there in the title. And then he says very clearly that a plaintiff, that's who has to prove standing under the law, may bring a summary process action to evict a tenant and recover possession, ... if the plaintiff is the owner or lessor of the property. Period. No ifs, ands, or buts. Right there, black letter. Couldn't be clearer. And then he quotes the opening section of the summary process statute. So the summary process statute is Mass General Laws, Chapter 239. He quotes Section 1. He uses the title. This has appeared in every one of our briefs also, because the title of that section of the law is clearly defining somebody who's allowed to commence a lawsuit or someone who has standing. And it's titled, the person entitled to land or tenements may recover possession. Person entitled, that's the party with standing, the plaintiff. So it's explicit, and he doesn't go into it here, but 239.1 is, remember my analogy of literally standing in front of the judge? 239.1 defines the threshold tests, the tests you have to pass one of to literally step over the threshold into the courtroom and do standing. And that's why I point you to Rosa, because Rosa quotes the section of 239(1), because it was an eviction-related case, that is the threshold that applies in our cases, which is where a party owns after the foreclosure of mortgage by the sale contained there, the power of sale contained therein or otherwise. Close to verbatim, you can look it up. Anyway, so he says you have to be a lessor or an owner. And he says that where the plaintiff is neither the owner nor lessor of the property, the plaintiff has no standing to bring summary process action, period. And he says that it is essential that there should be proof of the relationship of lessor, lessee, or between the plaintiff and defendant. And here's something incredibly important. So some of most of the causes of action or claims or statutes even that relate to court cases came out of the common law. In other words, there's a history of practice that eventually got defined down to something that's more of a logic test of some kind. That is not true for summary process. Summary process was created whole cloth as a series of statutes. So there's no wiggling around on what those statutes say. You can't say, well, it used to be interpreted this way, and when it got into law, it became this. No, there's no used to about it. The law is the law is the law. The black letter language of the statutes for eviction are what control. You can't reach back and say, well, this is how it got incorporated into summary process. And it really matters. So one of the things he quotes a case from 1950, Waja, that says summary process is a purely statutory procedure and can be maintained only in the instances specifically provided for in the statute. So where a plaintiff lacks standing to bring an action, the court lacks jurisdiction of the subject matter. So lacking jurisdiction of the subject matter literally means that the judge has no right to pick up the case at all. Back to my small claims judge who gets confronted with, was there a murder? And they go, sorry guys, go to a different court. You got a serious matter going on here, but I can't say a thing, literally nothing. So this is what we want, because here we've got the plaintiff. They've got to prove standing, or literally the judge in a summary judgment matter can say nothing.
Wrong venue.
Wrong venue, correct. One of the bases for a claim to a motion to dismiss. Wrong venue. Motion to dismiss. Subject matter jurisdiction, wrong venue, failure to state a claim, all flow from this.
3 legs of jurisdiction.
So what we want, though, is to look into what does it take then to prove standing. And that is where this all comes home to roost for the banks. So now I'm going to bounce you over to the Braxton decision. Braxton is a land court decision. I should say,
Braxton,
before we bounce off of Hatcher, one thing you may run into in dealing with the judges who are used to doing summary process because they don't read the case law or they don't understand it is they're going to say to you, well, Hatcher doesn't apply because Hatcher was about a standard tenant landlord case where the party that brought the case couldn't bring it. And one of the things that we have in the standard brief that I gave you, because we've rewritten it to incorporate this, but you can also point out, is the decisions that Gantz relies on in the Hatcher decision are foreclosure-related decisions. He knew exactly what he was doing. He couldn't give us a decision quickly on standing related to foreclosure, so instead he gave us a decision where he explicitly used the term standing, but then used the case law that he's referencing as foreclosure-related case law. If this decision did not rely on and did not apply to foreclosure-related cases, he couldn't have used the foreclosure-related case law.
not
So
only
you
that,
just point that out.
Not only that, but in that decision, he says, in all summary process case.
No, I understand, but hon, I'm telling you where people make mistakes, okay? And the issue is, you don't really need to correct me on this. The issue is that the judges say, oh, well, that was a tenant landlord case, and you need to point them out, take them right into the decision. Here is the case law that's being quoted. And in fact, he quotes Abate a bunch, which and the Matt decision, which were both decisions that came up to the SJC from the land court. And one of the things that I think probably was actually in our brief, which again may be why he did it, was that one of the judges had said, what are you doing referencing land court cases? This is summary process. A land court case couldn't apply. So he made it very clear that the land court cases do apply. All right, so I'm going to bounce you over to Braxton. And if we get down to bottom of page 4 in the Braxton case. So this is a land court case. It's a foreclosure related case, and it's a case where I think this is Piper, Judge Piper, is supposed to be doing summary judgment and then says, yeah, but I think we've got a problem with the plaintiff's standing. And I have to handle that first. And as he says, quote, standing is a jurisdictional requirement. I'm not going to quote the case law. You can see it as you read through. When a defendant challenges the jurisdictional standing of a plaintiff by motion supported by extra pleadings material, the defendant contests the accuracy rather than the sufficiency of the jurisdictional facts pleaded. So this is where we want to live. So if we've got a jurisdictional challenge.
He says at the bottom, page 4, you're saying standing is a jurisdictional requirement.
Yes. So if we've got a jurisdictional requirement, and the one we're using here is standing, and the challenge itself is a challenge to the facts or the accuracy of plaintiff's materials, this is handled differently than a sufficiency challenge. This is critically important to the law on this. We've got a lot of teaching the judges who don't already know this to understand it, but it's critical. One of the cases that keeps messing with us on our facts is the Hendricks decision. The Hendricks decision is being consistently misconstrued by the bank's lawyers. They're getting a ton of traction with it. And if you read Hendricks properly, it supports us. And they are misquoting it rampantly all over the place. So let me backtrack here.
Just a quick, can I just
Yeah.
briefly on the Hendricks, as I understand it, I was there when Tom was arguing the case. The issue there was...
Oh, no, I'm talking about the Hendricks one.
Oh, okay, well, the jurisdiction one, he argued that there was a challenge to the title, and he was not able to do that challenge in summary process because land court has exclusive original jurisdiction over any matters concerning registered land, which is
Correct.
us. Okay, fine. I just wanted to lay that on the table.
100% right about that. Okay. But what is also true is that he couldn't have argued in housing court more than a certain depth because housing court can't decide title on anything.
And
But it's
Judge
really
Maldonado,
registered land.
it wasn't Maldonado, I forget which one, but she said, well, we can affirm on any grounds. And basically, they just affirmed.
Well, no, we're gonna fight Hendricks. We're gonna win it. Hendricks 2, but I'm on Hendricks 1.
All right.
This is the original SJC decision in Hendricks, which was brought as unfortunately, a sufficiency challenge to the affidavits attached to the foreclosure. So, which is why this distinction is critical. There's a whole trail of case law here, going back to a fabulous decision out of Florida. But if you read Braxton, and if you want to read the Braxton citations, it'll take you happily down that thread, and it's fabulous.
Can you put the year down for Hendricks 1, if you remember, roughly?
We can look it up.
You know what? You can go to Google Scholar, scholar.google.com, and look it up.
But my instinct is that we're talking 2000.
Okay,
13.
Quite some time
It might
ago.
have been 2012,
not a problem.
but yeah. So the distinction here is the critical one. We have a tendency, particularly the folks who are pro se, who are trying to be nice to the judges and be polite, to go in and say, for instance, I've asked for the original note, and here's why I have a right to it. And then they say, but, you know, the bank hasn't produced it. This is a sufficiency challenge. You're saying what they have done is insufficient to prove their case, and you've left the door open. They say, oh, good, we'll bring it in. Judge goes, okay.
Which can be challenged at any time, even on the last stage of appeal and thereafter.
Yes, but it doesn't get us to the standard of review that
Oh.
we want. So you do not want to make this argument. You want to say, Your Honor, I've asked for the original note. What they've produced is a bunch of copies. The copies show that they don't have a legal original note, and here's why. So you need to go after what they did give you and show why it is not sufficient to prove, why it is not factually true, why it is a materially wrong fact, and why it isn't accurate. This does not say to them, you can bring in something that's missing. Oh, something's missing, bring it in. No, this is saying what you've given the court shows that you don't have it or you're wrong.
Case dismissed. Right?
Hmm?
Case dismissed.
Well, no, we'll get there though.
Okay.
It will be. So this is the critical distinction. You have to go in with what you've got and say, for instance, there's a rule that helps us. You ask for discovery, if you know what you're doing. You ask for discovery. If something's not provided in discovery, one of your standard questions is, give me everything you're going to use to prove your case. And they give you, quote, everything they're going to use, and they leave out the right to cure letter. Well, that's an element of the proof of the case that they have to have. And if they don't produce it in discovery, instead of compelling discovery, an option is keep your mouth shut. Yes, and then when they get to court, you say, Your Honor, they've no valid notice to quit, period. They don't have it. And they say, oh, wait, we do. And you say, no, you had to produce in discovery, or now at trial it's too late. You blew it. So it's a strategic choice. It's not one that our pro se folks have used, because I'm a little concerned about most pro se folks have got to learn how to stand up in court and stand firm, because the judge is going to let them wiggle out otherwise.
What if the judge says, well, why didn't you compel them if you knew it wasn't
Not your
missing?
job.
That's not-
Never your job to make the other side's case. You did put it in your
You
discovery.
requested it, right?
That's a great
You
question.
But if you didn't get it, it's up to you to say, hey, I didn't
No.
get it. I thought
No,
I
it's
thought
not.
that was
No, it
Okay.
is not up to you.
all right.
It is not. If you need it for your case, yeah, you should ask for it. But
Gotcha,
if
gotcha,
that they
gotcha.
needed it for their case,
Gotcha.
not your responsibility.
Thank you.
So this is what you want to go after. And it's critical. And now we're going to go back to Braxton. I'm going to show you why. Braxton then says, the plaintiff has the burden of proving the jurisdictional facts. And the plaintiff's factual, quote, averment receive presumptive weight. Disputed facts are not viewed in the light most favorable to the non-moving party, as they would be normally under the summary judgment standard. So the issue here is, in summary judgment, where basically they're skipping over the factual part of the case and jumping straight to, do we have any legal disagreements? Affidavits, averments means the same thing. It's an older term. People don't know it. But affidavits are the gold standard, because they're replacing the testimony that would have happened if you were at trial. So if you look at a standard of review, and remember at this beginning, we started with the issue of you have to tell the judge how to look at the evidence. If you look at the standard of review for summary judgment, where they're not going to trial because the other side is claiming there are no disputed facts, affidavits are the gold standard if they're true, which of course the affidavits we're seeing from the other side are overwhelmingly not only not true, but they don't have competent affiants. They don't have somebody swearing to it who actually has a basis that is personal knowledge for knowing what they're saying, or a basis in review of regularly created business records, right? They're just making it up as they go along. But under summary judgment, you're not in a great position with that, because summary judgment relies on affidavits. It's how it gets away from having a full trial where you can question both sides. So as he says here, summary judgment gives affidavits a lot of weight, and, quote, disputed facts are not viewed in the light most favorable to the non-moving party. So in other words, there's a bias there in the summary judgment standard, that it doesn't help out us as defendants. However, when the materials submitted present a factual challenge to jurisdiction, as opposed to raising the legal sufficiency of uncontested jurisdictional facts, the plaintiff's allegations are given no presumptive weight.
Question, that's a dissenting opinion, though. It's not part of the majority opinion.
Don't worry about it. There's a case law all the way down the road on this.
This is very technical stuff.
This is critically important stuff. So the issue here is, and I've not, yes, plaintiff's factual averments receive no presumptive weight. So literally their affidavits get no weight. Now, when a judge is weighing a decision, that really matters. It means essentially that the plaintiff's affidavits are useless to them.
Only for a jurisdictional or standing
Jurisdictional standing
okay.
challenge based on wrong facts or inaccurate facts.
Okay, so that's a different standard of review than what affidavits will get for the substance of whatever the claim is.
Right. Well, the issue is in summary judgment. If you read the standard summary judgment standard, it all over the place is saying, you put in your affidavits as a plaintiff, and if defendant doesn't put in their affidavits to defeat you, then the defendants are indeed, what?
The standard of review is in viewing the facts in light most favorable to the non-moving party, there is no genuine dispute of material fact, and the moving party is entitled to a judgment of law, and that's what they get.
Exactly. You've got it memorized, I know. But the upshot of it is that they come in with their whole, so can you see over here?
Yes, we got
Okay. In a standard foreclosing entities case, right? If we've got the foreclosing entity is the plaintiff, and because of the standard laid out in the Bailey decision, which, by the way, is hopelessly misinterpreted, and maybe I'll say something about that if we have enough time, they are going to come in with a foreclosure deed. This is a foreclosure deed that is completely dependent on an affidavit that is attached to it under 244, Section 15. They are going to come in with an affidavit saying that the relationship to the note holder is fine. They're going to come in with an affidavit saying that they complied with the state's loan mod program. They're going to come in with an affidavit these days, more and more, that is referred to as a Pinty affidavit, that says that they complied with the right to cure law. And this whole case depends on affidavits, this one being the most important one.
Can you mention the sections, because I can't see it too well on the camera?
Okay, so the foreclosure deed, the affidavit is 244-15, right?
Yes.
The affidavit for the note holder is 244-35C, but it's usually referred to as an Eaton affidavit. The affidavit related to the state's protected loan mod offer requirement is 244-35B. And the Pinty affidavit is actually just a creation off of 244-35B and 244-35C. It's not in statute yet, but it is trying to back up the right to cure statute, which is 244-35A. So this is their whole case. They depend on these documents. So if you go in with a sufficiency factual challenge to their standing that raises the jurisdictional issue, guess what's out?
All the affidavits.
All the affidavits are to be given no weight. That means in the judge's decision, they are not supposed to be a consideration.
Quick question. If I'm challenging, for example, the 35B affidavit, because I can prove that they did not act in good faith in offering a loan modification, then how, and that's a jurisdictional challenge because 35B says that they're not supposed to advertise for the sale unless they comply with this.
And that's what includes reporting this true affidavit in the Registry of Deeds.
And from a jurisdictional perspective, how does that taint or reduce the standard of review from plaintiff's favor to defendant's favor?
Well, now what you have.
I mean, at
you
15, all the other affidavits.
I'm with you.
Okay.
Got the question. So the reason is that they have a fact that they have to prove out of the many chain of facts for a valid foreclosure.
Yep.
You have brought in a challenge that is an accuracy challenge to what their affidavit. You've brought a factual challenge. You have to have something that shows factually that they failed their obligation to properly carry out this law. Having factually failed an element that they needed to prove to show they owned the property, you have challenged their standing. Remember Hatcher?
Yep.
They've got to show that they're the owner. So you have brought a factual challenge to one of the elements that goes to whether they're an owner, and that goes to whether they have standing to bring a summary process case, and therefore a jurisdictional challenge. So you got yourself exactly where you wanted to be. You've got a factual challenge to their claim to ownership, which goes to their standing to bring a summary process case under the jurisdiction of summary process.
So you're saying I make a challenge to 35B that mandates to the judge to look at the rest of the other three affidavits on a lower standard of review and give them no deference at all? Okay, but if it's a substantive challenge,
it has to be factual and it has to be something that you didn't raise as a sufficiency challenge.
Got it.
You've got to avoid this. If you say simply, well, they didn't prove it, that could be interpreted as a sufficiency challenge or a factual accuracy challenge. You want to say, Your Honor, their facts show the opposite.
right? And the standard for summary judgment is they come up with an affidavit. It's prima facie. You can't just say, "Well, I disagree with that." It's not going to overcome that affidavit.
Right, but I'm saying not only do you need to bring the facts, you need to frame it not as a sufficiency challenge. You have to frame it as an accuracy challenge. Something is wrong. Something they're saying is factually, you have evidence that it is not true.
This is a key distinction. If you don't mind me.
It's the whole ball of wax.
Gnawing on it for a little bit. The sufficiency challenge could be, for example, the sufficiency of someone's relationship to the business records. Like if they only started there one day and they can't really, they don't have sufficiency of experience or training or even interaction with the business records. That's a sufficiency challenge.
Right.
I might win on it, but depending on.
It doesn't change your standard of review.
Doesn't change the standard of review. It's the facts. So, for example, in one case I have in the 35B, I challenged exactly what you said there, the jurisdiction, I challenged the sufficiency of the affidavit because there was no record for MERS. And they say that we checked all the computer records, everything, and yep, our servicer is a servicer for the owner.
That is something that can fix. If you come in as a sufficiency challenge,
right,
you've left the door open to them showing something different. So I'm going to go back to my note example, even though we haven't gotten judges to look at notes, right? So they say, you say, I asked for the original note, they never gave it to me. You don't stop there because that's a sufficiency challenge. They can say, well, we'll bring it in. No problem. We're covered. Instead, you say, but I did get 3 copies. Each one of which they said in some context where they are saying it's a true copy, the 3 copies don't match each other. And if you look at the dates on them, they couldn't be the sequential development of an original document. It's not possible. So what they've given me is evidence that they don't have the original note. Because here they've given me documents that are attached to a certificate where they're certifying. They've given me a document under RESPA where they've attested to the, on it says true copy, blah, blah, blah. And I've got the dates when I got them. And B could not have been a copy, a later version of A, if C is also supposed to be a later version of A, because B and C could not be the same document. That is a factual challenge. And now it doesn't matter what they bring in, because they've given me evidence that they lied and that they didn't have the document on hand and that they tried to use the document that they created, claiming it was an original, to beat me in bankruptcy court or to send me a notice to foreclose or whatever it is. They've relied on it legally, and it couldn't possibly be the same note. That's a factual challenge.
Once a liar, always a liar.
Okay.
Everything is in doubt.
Couldn't they say-
Once they've, right, everything's in doubt now.
But couldn't they say, well, there's one copy that you got in your debt validation request 2 years ago that didn't have the true copy stamp on it, but the one that they brought into court.
They relied on it. The issue is they gave it to you to rely on it. It was a legal act. Yes, if you happen to be hanging out in the bank's law office and there was a document lying around that said it was your note and you happened to pick it up and take photographs of it and no one was saying to you that that was your note, yeah, I think you've got a chain of custody. They could say, no, that was just a copy that was lying around. It was 5 years earlier. Just because it happened to be lying there doesn't mean anything. I'm talking about where you got it in a legal context, where they were telling you to rely on it.
What's a QW?
Okay, so yes, like the qualified written request. So, but this is it. This is where you've got to live. And if you can live here, now we're happy, because all these affidavits are out. And the statute under 244.15 specifically says, if you can't meet that, your affidavit's no good there, then you've got to bring the actual evidence in. So now they're in trouble, because if you look at the number of elements that have to be proven for a foreclosure to be valid, it's something close to, it's well over 100 elements. And they don't have them. They don't usually have, and you know, if you made a list of the top 25, they don't have the top 25.
Okay, so to really meditate and do the good reading that I have to do on accuracy versus sufficiency, is it Braxton?
Yes, and
Okay.
it's the cases related to Braxton. I'm going to take you back to Abate, because Abate incorporates a lot of this.
Okay, he's brilliant, that Foster.
Yes, the problem is we've got to get them here, and we can get them here in land court.
Yep.
Because the party that's usually bringing the case in land court is still the bank, and they can't meet the standards for standing.
You said we need to go get the land court record, right?
No, I didn't say that.
No? Okay.
We also, yes, you should, because there's
service
an
record.
affidavit in the land court
Yeah.
that could also be a lie that could throw out
Okay. So it would be
their
good to get
standing.
that copy of the.
I'm a big one for go and get your
Yes.
active military service proceedings. Sometimes they're in Superior Court. But
Okay.
yes, get that file.
Yeah.
Because 244.35A requires them to put a copy of the right to cure letter. And given when Pinty came down, we go, and then Marroquin, we go from them basically scrutinizing a lot of the judges scrutinizing the letters under Mass General Laws 244.35A. Then we get the bad decision in Schumacher. No one's scrutinizing the letters anymore. And then Pinty comes down, and then Marroquin comes down, and now they're scrutinizing the letters. In between, there are 3 or 4 years where they sent right to cure letters that were not going to meet any standard of any kind. They had to put a copy of it in when they did the active military service proceeding, each time they did it. And so if you can go get it, you will find, more than they are willing to admit, that the letter they put in that filing 4 years ago is not the one they're going to bring into the eviction case. They lied on their affidavit in the land court case.
It's huge.
And so it's huge. You've got to get them.
Okay. For clarification, you didn't mention that today. You mentioned a service member case earlier in the week. That's all.
Yeah.
Thank you.
No, but it's a really good example. Anyway, the reason the nice elegance of this is that now you're stuck usually. I'm hoping we're going to start using this for motions to dismiss immediately in these cases when we've got the evidence to do it. But for now, it's mostly coming up because they've moved to summary judgment. And the key issue is you've got to convince the judge that, having gotten their case on some factual inaccuracy, the judge can't use summary judgment standard. because proving jurisdiction must always, always come first. So you are literally saying to the judge, we are now rewinding all the way back to this very first filing by plaintiff. We never got to summary judgment in terms of the timeline until standing has been proven. So they must go back to the jurisdictional standing issue, and they've got to let go of the summary judgment standard and instead use what eventually is an evidentiary standard. All they can do is look at the primary evidence from the plaintiff. Okay, so back to Abate. Now, the Abate case was a land court case. The nice thing about this is that in Hatcher, Gantz relies on Abate a bunch. So they can't go, oh, that's a land court case. We don't have to look at that. So let's see. Abate gives us a number of things. One is, it says that once the Prima Facie case has been established, it's up to the defendant to bang away at it. Once the defendant has banged away at it, what is the judge supposed to do? So the judge realizes, uh-oh, I've got to look at jurisdiction. What is the judge required to do?
They're required to decide the issue of jurisdiction. If at any time a party raises the issue or the court on its own motion sua sponte.
Right. And nicely, Hatcher, again, summary process case, says that exactly that quote from Matt, that the judge has to deal with it as soon as it comes to their attention in any way, or they have to deal with it sua sponte if the defendant is not present. And Abate says, the appeals court held that a reviewing court shall accept as true all prima facie evidence of personal jurisdiction unless contradictory evidence is introduced, in which case the plaintiff must, quote, establish jurisdiction by a preponderance of the evidence at an evidentiary hearing or at trial. So you get to go in and say, Your Honor, we should be doing, here's my factual, usually several, factual challenges to plaintiffs' claim that they own the property. The claim that they own property takes them to the standing question. The standing question raises jurisdiction, and therefore we need to shift out of summary judgment and jump over to an evidentiary hearing or trial. And so then it says a judge has discretion to hold a hearing prior to trial to determine subject matter jurisdiction. There is no impediment to a judge holding a hearing to determine the accuracy of the alleged jurisdictional facts in the first step of, in this case, a tri-title action. The same would be true here in summary process.
What page of Abate?
I'm on page 17.
Thank you.
If a judge holds a hearing to determine the facts necessary for the petitioner to establish record title and possession in the first step of tri-title action, the petitioner is required to establish those elements by a preponderance of the evidence standard. So if we bounce then back to Hatcher.
So jurisdiction is a preponderance of evidence?
Yes, but it's primary evidence. So their problem here is that once we get them into primary evidence, they're in trouble.
Do you mean direct evidence?
I don't know the term.
Okay.
Can you help me?
Direct evidence is I witnessed the crime in the act.
Yes.
Direct is, indirect is, or circumstantial is, I saw the footprint of the perp published on TV, and my roommate has the same shoe imprint. That's it. That's circumstantial. Direct and circumstantial. So when you're saying primary, I'm thinking, is it you should mean direct?
I suspect that they would prefer direct, but what makes it primary is that the plaintiff's affirmance are out.
Okay.
So they've got to go to actual evidence. They can't say I don't know, it's not coming to me.
Public record documents are out. They have to bring the originals.
Right, they'd have to bring original documents. They'd have to bring in, instead of saying, well, somebody at our business did this, they'd have to bring the person who actually did it.
No hearsay, basically.
Well, they aren't allowed hearsay anyway, but it's the issue is, instead of saying we have an affidavit saying that we are the owner of the note, they have to show up with the note, and they have to show up with the fact that they bought the note and all the proof related to that.
Instead of, I think it's instead of evidence, you gotta bring proof.
Yes. Okay. I don't know the distinction of that. But so this really matters, because once we get into this standard, when we go back to Hatcher, there's a whole lot of awesome stuff. So in Hatcher, let's see if I can make this happen. He's worried about the camera.
Yeah, I wasn't blind.
Anyway, you'll see that the citations in Hatcher about this issue are the same ones in Braxton and in Abate. So they're reaching for the exact same standards. Whenever it appears by suggestion of a party or otherwise that the court lacks subject matter jurisdiction, the court shall dismiss the action. Quote, subject matter jurisdiction cannot be conferred by consent, conduct, or waiver. And then in Hatcher itself, we therefore hold that whenever it becomes apparent to a court in a summary process action that a plaintiff may not be the owner or lessor of the property at issue, the court is obliged to inquire into plaintiff's standing. And if it determines that the plaintiff lacks standing, it must dismiss the action for lack of subject matter jurisdiction, regardless of whether any party raises an issue of standing. And then this is our favorite close here in terms of the argument in Hatcher, quoting Abate. Although dismissals for lack of subject matter jurisdiction are ordinarily without prejudice, because they typically do not involve an adjudication on the merits. In cases where a lack of standing is also fatal to the merits of plaintiff's claim, as here, dismissal must be with prejudice. Where the complaint is dismissed with prejudice for lack of subject matter jurisdiction, the plaintiff cannot file a new summary process complaint against the tenant unless he or she subsequently becomes the owner or lessor of the property. So the key here is that you've got to make sure you've got enough evidence to throw out their prima facie case, probably.
And that's exactly what I've been talking about.
But you want to get them here. I wanted you to learn this, because you've got to force them to the evidence. And force them to the evidence so that it's not all of their bad affidavits up against us trying to put in a bunch of affidavits. We've got tons of primary evidence. We want to force the judge to primary evidence. I'm going to say one more thing in closing, which is they are quoting the Bailey decision. So the Bailey decision came down in August of 2011. It's the first big decision related to a eviction case after a purported foreclosure. And in the Bailey case, they go back in the case law quite a long way. And they look at cases, gosh, all the way back to the early 1800s. Is that possible? No, must be a case late 1800s. Anyway, to look for what do you do, because there hasn't been many foreclosures in 150 years. So the case law is old. And what they say is that for an eviction case, what the plaintiff who claims to have the property after a foreclosure has to prove is that they obtained the deed to the property and recorded a foreclosure deed and affidavit. They come in and they say, we've got a foreclosure deed and an affidavit. They skip having to prove that they obtained the deed.
By strict compliance with
They are misinterpreting, and they have happily chopped out a piece of the Bailey decision, the foreclosure deed and affidavit being recorded, and said, this is our prima facie case. It is not. Your prima facie case is that they obtained the deed and recorded a foreclosure deed and an affidavit. So because of the misinterpretation of Bailey, it's critical that you throw out this affidavit, because it throws out the presumption that they have a prima facie case. But you wouldn't actually, if they were reading the law, have to do that. You could go after anything related to obtaining the deed, because that's what Bailey actually said. They then go on to misquote Hendricks 1, the SJC decision, where Hendricks 1 says, look, you only need a foreclosure deed and an affidavit in the registry of deeds. It's presumptive good evidence. But they're talking about the standard required for the registry of deeds and for some third-party purchaser to come in and rely on what's in the registry of deeds. There's a sloppiness in how they wrote it, but they then say that once you bring the foreclosure deed and affidavit into court, it is just evidence like any other evidence. So it's not enough to prove their entire case for an eviction case. They've mushed together the Hendricks analysis of what's needed for the registry with what's needed in court. And in Hendricks 1, the court specifically footnotes that they've only been asked in Hendricks 1 about a sufficiency challenge to standing, that Hendricks did not bring a factual challenge. So they kind of opened the door to saying, guys, you're looking in the wrong place. You should have brought a factual challenge to the affidavit in the post-purported foreclosure eviction case in Hendricks, and you didn't. You brought to us only a sufficiency challenge, and we can't get very far with that, the SJC says. So you will see, and you've seen this a bunch, if you've seen these cases, you guys should have, that in their standard argument, the bank's standard argument, they will come in and say that if you challenge this affidavit, they will say, go look at Hendricks. Hendricks said as long as it was in the statutory form, we're good. So you can lie, their argument. You can lie through your teeth all the way along as long as it's in the statutory form.
Unless, well, it's prima facie truth unless you can prove it's a lie.
That's not what they say. What they say is, we go in.
Because it's the statutory form, not because it's the truth.
Exactly. And they,
so yeah, the white on the page is, hey, we can lie all we want as long as it's in the statutory form.
And there's no way that's what the legislature or the SJC meant.
Yeah,
the same thing is true here when they come in with these affidavits. They will say, well, we've written down that so-and-so is the note owner and that we are their agent. And so we're good. The fact that it's a lie, they say as long as we met the statutory requirement. There's no way the SJC, in talking about 183.5b affidavits, well, actually, they did put down a case saying it has to be true. That's the Bank of America v. Casey case. But before that, they had said in Eaton, they had said in Pinty, look, you can put in an affidavit in the registry saying this to the banks, and that's enough. But they assumed that when they said affidavit, it meant it would meet the requirements of an affidavit. And I mean, why would they say that? They don't need to say that.
Right.
But the banks regularly come in with their briefs in eviction cases and say, the court said we could put in an affidavit. We did put in an affidavit. We write, this is how the affidavit is factually untrue. And the judges say, well, but they put an affidavit in and that's all the SJC or the legislature told them to do. And it's ridiculous.
See, the difference between evidence and proof is like the registry documents, that's evidence.
Correct.
The proof is if you bring the original in. It's like...
Actually, proof is something that the judge decides based on what you brought them. But
right.
Yes, I understand the distinction you're trying to make.
If you have a bunch of evidence, it could lead to proof.
Right.
But it's like you bring in the duplicate of a check, right?
Right, that's not
evidence
anything.
that a check may have happened, but it's not proof.
Okay, can I raise something? I'm looking at the standard eviction form.
Yeah.
And that's the complaint they send you. They really don't send anything
They're not
else.
allowed to send anything else.
Really?
No, under summary process rule 2, that is the document.
So you can challenge the complaint because what they write in there, you continue to
Hold over after the
hold
foreclosure.
over after the foreclosure. So I mean, just this form alone, unless they state sufficient
The court
facts.
has the right to public notice of anything in the public record. So because summary process rules are different,
Okay.
you have to learn the summary process rules. They are our friend in these situations. Fabulous friend. So they put on their complaint, all they're allowed on the form, on the directions, is what they can fit in that little slot.
And what they should be saying is plaintiff acquired title to property by strict compliance with the statutes related to foreclosure and terms of the mortgage. Defendant continues to hold over after having been received a
They don't
complaint.
have to do the second part, because the second part is in the summary process rules. They're allowed to put in the notice to quit, and it should be self-explanatory that the notice to quit met their obligation.
Got it. Okay.
But you're correct that slot is big enough for them to do a proper recital.
So if they don't,
they could absolutely say, we are the owner after, as you said, a foreclosure under strict, or if they bought back, strictest compliance standard, and we sent the legally required default, right to cure, affidavits in the registry,
Military.
notice of sale. That's not required to foreclose. Notice of sale, the accounting's accurate.
It's required.
They could put that in there, because we do that in one sentence on the appeal bond forms. We put in a whole slew of words.
Well, they can annex another page if they have to.
No, they can't. I just
No?
said they can't.
Oh.
The summary process
Gotta read the
rule 2
rules.
only allows them to use that form.
Gotta
The
read the
form
rules.
is it. They have to put that in. They have to put in the notice to quit and service, showing service of the complaint and service of the notice to quit.
okay, so I'm looking at Vital's summons a complaint right here. I just went on to masscourts.org. And let's see what they say here. Court address, 225 Main Street. Okay. Beginning with the judicial review, unlawfully and against the right of said claimant landlord owner, because your tenancy was terminated for cause on August 1st, 2008, and you remain in possession, breach of lease agreement. What lease agreement? You got a lease agreement?
No, that's correct.
That's not Vital. That's 2 Bancroft Street.
But it doesn't matter. It is similar.
Right.
They do say the problem is that they violated the tenancy.
Kevin
But in their
Rosario. That's
argument
somebody else.
for
But
summary
there is-
judgment, they say that they were never bona fide tenants and they're squatters. So they're trying to change that. All that one sentence said in the complaint,
motion
they're
is
trying to
right.
bring them in under a different basis in the summary judgment.
Well, they made a fruit salad over there. They make
No, no, no,
inconsistent
no.
allegations.
The
Totally
summary-
different.
yeah, that's true, but the summary judgment literally chose a different basis for eviction than stated in the complaint.
Okay.
And they don't own anything anyway, so they're in deeper trouble for that. But so you got this.
I'd like to take a picture, but I'm definitely read into those cases. And I
Anything sanctionable here
well,
for the attorneys or the other
The
side?
problem right now is that we have a
Plaintiff.
really steep pile of what that we've got to.
would
get
that be
rid of.
doo-doo?
I didn't say it.
Poo-poo.
The briefs, I think that probably, Richard, if you wanted to, sort of do a project with me, we would go through their briefs, the bank's briefs. There's a ton of sanctional stuff in there.
Okay.
Not so much this stuff per se, but they not only do they bend decisions like Bailey and Hendricks, but they literally rewrite some of the decisions in their standard briefs. And that
It's
is
sanctionable.
sanctionable.